I'm okay.
SJC-10200, Commonwealth versus Taylor.
Good morning, Mr. Safar.
Good morning, Chief Justice Marshall, and may it please your honors. Aziz Safar on behalf of the defendant, Kenneth Taylor. This case is here as a result of the defendant's conviction of murder by deliberate premeditation with an ancillary conviction of armed home invasion. And the defendant is concerned with whether the trial errors individually or together gave an undue air of credibility to the Commonwealth's two key but suspect witnesses. The first point, which was not preserved, involves the prosecutor's misstatement that Charles Rich, and the misstatement was made during the prosecutor's closing argument, that a witness, Charles Rich, testified the person Rich saw holding the gun essentially fit the description of the defendant, a person Rich's size of 5'8" with a medium build. However, Rich never made the statement, and even looking back into the first Taylor trial, the statement that Rich made in full was that the person that he saw was a little taller than he was and a little huskier than he was.
But does it, in this trial, the second trial, Seltzer, I believe, described the same person that Rich also saw as being sort of Seltzer's height and size, right? I mean, well, in other words, physically the description that was attributed to Rich was given by another witness. I guess that's, does that help?
I don't know if I would agree with that, Your Honor, respectfully. The height that Michael Seltzer had given was 5'10", which is neither the defendant's height and it's not Cooper's height. And the theory of the defense was that...
One of them's 6 feet and one's 5'8", is that...
Right. It's kind of vague, and I know it's in between. It's vague in that area, and it's not. It was a person that he had seen exiting the apartment, walking on the driveway, and a gun shot had fired on the driveway. The person that Rich said that he had seen was on a landing. He had bumped into that person.
So it's at a different place.
It's in a different place, and it doesn't implicate the build and the height of the defendant, such as the misstatement does, which is right on, 5'8", medium build. So that statement and I thought about that, is somewhat vague in the context of this case, given what the prosecutor had said.
And I take it you would say that the fact that the defense attorney also misrepresented, I don't mean that pejoratively, but
well, this court
had an inaccurate description of the
right.
Of the witness.
And nobody's suggesting ill will as a prerequisite for the defendant to prevail on this.
Right,
on this
and
claim.
I'm not suggesting that. But does it matter at all that the defense attorney?
This court has repeatedly said that fighting fire with fire is an inexcusable approach. Or maybe the better thing to have done here was if the prosecutor would have corrected the record and said, well, Rich never had said that, or this was a mistake. But that's not what happened here. Essentially, what happened was that the prosecutor was vouching for these witnesses, Cooper and Nelson, with evidence that was never given. So that's very different. I know that the Commonwealth stresses this point in its brief, that there was some type of mistake that the defense attorney had made. And I think the actual testimony in this trial by Rich was that he had bumped into a hard-bodied individual.
Right. He didn't say anything about size.
He didn't say anything about size, stature, and what the defense attorney had said, well, he bumped into a large man. And that went uncorrected. That's correct. But I think that the misstatement really made Nelson and Cooper appear more credible. Cooper was testifying pursuant to a cooperation agreement, and he said that after the shots were fired in the victim's apartment, he saw the defendant carrying a gun. And Nelson also, who was in fear of losing custody of her child, testified that after she heard the loud popping sounds, she saw the defendant exit, re-enter the car and tuck what appeared to be a gun in his waist. She also said that later on She saw the defendant attempting to place an object under the mattress in Daniels's apartment, the place where the party had gone after the incident. So the prosecutor's misstatement, made in conjunction with urging the jury to find Nelson and Cooper more credible, really raises the concern that it caused the jury to likely improperly set aside their suspicions toward these controversial witnesses. And I supplemented my brief with the Silva Santiago case, and to the extent that there were misstatements, I know those misstatements were objected to in that case, but to the extent that the judge instructed that closing argument was not evidence, this court still went on to say, well, we have no assurance that these misstatements did not influence the jury, and I suggest that here it's even more so. I know that case dealt with a 15-year-old witness who gave some pivotal testimony, but the quality, the reliability of this evidence, I mean, they had a stake in the criminal trial. And as I stated, not only did the misstatement lend more credibility to those witnesses, but it also unfairly damaged the defense that Cooper was the shooter. Cooper was 6 feet tall, he had a large build, and now the prosecutor's misstatement that's imputed to Rich has a witness with no apparent incentive placing a gun in the hands of someone with the defendant's height and physical build.
At the first trial, the one that ended in a mistrial,
Yes.
what was the Commonwealth's theory as to the shooter? Was it also the defendant?
It was the same.
Okay.
Well, in that case, there was a difference, actually. The theory on which they presented felony murder was based on the armed home invasion, but this court, and you know this case as a whole has a long procedural history, right. And they withdrew that based on issues that were pending in this court. There was a sentencing anomaly, a legislative sentencing anomaly with regard to that, and they retried him in connection with the felony murder on an attempted armed robbery rather than the armed home invasion. But everything else, to my knowledge, was pretty much the same. I don't know if the court has some questions on this issue.
Do you, in the Silva Santiago case, the misstatement in the closing argument was, I think this court felt, to be an absolutely key point. And I guess you would say this is as key, if not more. Is that your point?
Well,
in other words, it has the same relative weight to the whole trial as in that case?
Well, to the extent that...
Well, I'm reading from your brief. It says the error went to the heart of the case.
Well, it went to the heart of the case in that the quality of the evidence that implicates the defendant comes from these two individuals who have an incentive to falsify, to fabricate. One's testifying pursuant to a cooperation agreement, and the other, she felt that she was threatened to lose custody of her daughter to DSS. And in that regard, when you inject into this a statement that was never made, in fact, it wasn't even made in the first trial. I mean, a portion of the statement was excised. He said that the person may have been a little taller, may have been a little huskier. That's not the exact statement that was made. And you inject that into the analysis, into the fact-finding that the jury engages in, and it certainly makes these witnesses appear more credible. And recall that the first trial did end in a mistrial. And I would suggest that's because of the poor quality of the evidence that was presented, that these witnesses did have these incentives. And it also hurts the defendant's defense that Cooper, Burton, and Nelson colluded, conspired, and sought to set blame on him as the outsider. He was the so-called newcomer, and the trial attorney even used the rhetoric they sought to throw him under the bus. So this hurts that theory because now you have a purportedly neutral individual that's bolstering.
That's Rich.
That's Rich.
Yeah.
Who's essentially injecting an air of credibility into these somewhat controversial witnesses. So in that regard, yes, it hurt the case. And at the heart of the case was the defendant's theory of the case that Cooper was the shooter and not himself. I'd like to move on briefly to the next point, which was preserved by objection, and it was the judge's limiting defense counsel in the cross-examination of Cooper. And the defense counsel had made an offer that Cooper was being selectively biased in not testifying in Burton's trial, but testifying in Cooper's trial.
When was Burton's trial?
August 16th, 2005 was the commencement.
And this one was?
The second trial was in 2006, so it was past that. But I'll come to that point because it also implicates an issue with regard to the cooperation agreement. So the judge foreclosed the line of inquiry on the grounds that Cooper may not have had an agreement available to him at that time and was therefore privileged not to incriminate himself, was the judge's reasoning. But there are cases like Barnes and Commonwealth versus Funches that state that where a witness has a stake in the case or has criminal complicity, some criminal responsibility in the case, that the trial court should offer much more liberal cross-examination.
Do we know factually, and it may be in here, and I'm sorry if it is, sure, but do we know factually what were the facts of the Cooper's having an agreement or not having an agreement at the time of the Burton trial?
Well, first of all, the agreement was signed in February of 2005, over 6 months prior to Burton's trial. So as a practical matter, there really was no fear or danger of jeopardy. I mean, if he follows through on that. I mean, and the other thing is, given the tenor of...
I'm sorry, the agreement with Cooper was signed before the Burton trial?
That's correct.
But did not include his testimony in the Burton trial?
Did the agreement say anything about specifying where he would testify?
Yes, it did.
And it was only as to this defendant?
That's correct. That's correct. But that's exactly the type of material that should be before the jury so that the jury can fully assess the entire context of this agreement. Because remember, the theory of defense here was that they plotted against him because Cooper was the shooter. And why didn't he testify in the other fellow's trial? He's really not in jeopardy. He's got this agreement now that predates the commencement of that trial. Why didn't he do that? And I know my brother counsel is stating that the offer that was presented was conclusory. But if you look at the case, you look at the defense that was up before judge and jury before that time, and you combine it with what he was saying, I think it was a legitimate area for cross-examination, especially given Cooper's involvement in the case.
Help me to be clear on this. Was there a written agreement with Cooper?
Yes.
And the written agreement with Cooper said he will cooperate and testify against Taylor?
That's correct.
But did not say anything about testifying against anybody else?
Not that I recall. That's correct.
And he didn't testify against anybody else?
He did not.
And was there any cross-examination as to the limitation in the agreement?
It wasn't permitted to.
It was foreclosed on that ground.
The judge objected on citing First and Fifth Amendment grounds?
Yes, Your Honor.
What's the First Amendment claim?
I'm confused with that. I am not certain if the allusion is to some freedom of association. I'm not sure. I'm guessing. I don't know. And even in connection with the Fifth Amendment citation, I thought to myself, well, here he is. He's testifying. He's really not in jeopardy of being incriminating himself. He's got this agreement. He's following through on the agreement. I don't know what the point of that was, and I think in the context of this case that cross-examination should have been had for these limited impeachment purposes.
What was the basis? Did the judge ask the Commonwealth? I mean, what you have is objection sustained. What was the Commonwealth's explanation for its objection?
Without looking here, my recollection is that it was speculative that the offer was inadequate and conclusory. However, as I said, if you combine that with the tenor of what took place at trial, the facts that preceded that were before the judge and the jury, the theory of the defense, I don't think he had to bend over backwards to...
I think the Chief Justice's question is that there was an objection by the Commonwealth sustained. Then counsel went to sidebar, right?
Yes.
And then did
she ask the Commonwealth on what basis it was objecting?
Give me a moment.
I'm looking at page 26.
Yes, if my recollection is she did.
I have what defense counsel said, but not what the Commonwealth said. I'd like to know what the Commonwealth's objection was, the basis of that objection. We can look it up, Mr. Safar.
Yeah, I think the objection was that there was no sufficient nexus shown to be demonstrative of bias in that regard. But I'm looking for the exact quote, but I think that's what it was. And then the defendant's attorney objected to save his rights. Any more questions on this issue? No? Your Honor, at this point, I'll rest on my brief.
Thank you, Mr. Safar.
Thank you.
Good morning, Mr. Bradley.
Good morning, Your Honor. May it please the Court, John Bradley for the Commonwealth. As the Court probably knows, I was also trial counsel, and I'm here today to acknowledge the fact that I did make a mistake in my closing argument. I did, in fact, misstate the evidence when it came to Charles Rich's testimony. But my point here today is that that mistake did not result in a substantial risk of a miscarriage of justice. There was no objection, obviously, by trial counsel. The point I was attempting to make in describing, in fact misdescribing, Rich's testimony did not go to the heart of the case. The cornerstone of the Commonwealth's case here was the combined testimony of Joseph Cooper, the cooperating witness, and Natasha Nelson. Rich's testimony was more in the way of window dressing, if you will. The mistake I made went to a lack of physical description that Rich simply did not provide. He described the gunman's clothing, he described the mask, he described the fact that he had a gun. I believe what I did was I cross-referenced testimony from the first Taylor trial, or perhaps even the Burton trial, in making that mistake. As I pointed out in the brief, what I'm guessing, going back in time, got me going on the issue was the fact that defense counsel had previously mischaracterized Rich's testimony. He described Rich as saying that he had bumped into I forget whether he said a big or a very big man in describing the masked gunman. He said, defense counsel gave that description twice, and in so doing, mischaracterized what Rich had said, because Rich didn't describe the physical stature of the gunman at all. I then, in response to that, got up and committed my own mistake. What I will say is that I led into that by explaining to the jury that it was their memory of the testimony that controlled. However, I suggest Rich described the gunman as being a guy that was basically his size.
You would agree, and I accept exactly what you say, it's a mistake, but you would agree that the fact that the defense, as a legal matter, the fact that the defense attorney also mistakenly characterized the testimony doesn't justify the Commonwealth's mistake.
Well, with all due respect, Your Honor, I don't know that justify is the right word. I don't think defense counsel did it intentionally.
I'm not saying anybody has any bad motives.
I know. It's not a fight fire with fire thing, because it's not intentional on either part, I don't think. But what I will say is this: in the Bradshaw case, way back when, this court said that the jury can be expected to take argument from both sides with a grain of salt. And for that reason, I do think that it's relevant that defense counsel also mischaracterized the evidence. The fact of the matter is, unlike a lot of other states in this Commonwealth, we don't have the benefit of real-time transcripts.
We are getting closer there, we hope, Mr. Bradley.
Well, I can tell you, Your Honor, just as an aside, that it would be a tremendous benefit to trial attorneys. I can tell you that I would use them regularly. I would quote from them, as would, I think, most experienced trial attorneys. And because of that, we're going to see more mistakes when it comes to referencing specific bits and pieces of testimony. That, in my opinion, magnifies the importance of the instructions that trial judges always give, that the closing arguments of counsel are not evidence. Now, I know that both this court and the appeals court have described that particular instruction in various cases as boilerplate. And frankly, I take issue with that. It may seem boilerplate to appellate judges who have seen it thousands and thousands of times, but it's certainly not boilerplate to a jury who is hearing it for the first time. The instruction is not one that's given any less weight than any of the other instructions given to jurors. Unlike a lot of the other legal instructions that juries get, it's remarkably easy to understand that openings include.
Did this case only last 2 days?
Yes.
And when did Rich testify I mean, was he one of the early witnesses, one of the late witnesses?
You know what, Your Honor, I simply don't recall.
Did the closing arguments? I'm sorry. Go ahead.
I'm sorry.
Did the closing arguments also? Did they take place on the third day, or did they take place on the second day?
I believe closings were on the third day.
Okay. And was there like a weekend in between?
I don't recall that, Your Honor.
So is it fair to say that the jury heard Rich's testimony within 2 days of the closing arguments? It could have even been 1 day.
I think that is fair to say, yes. And, you know, it's if you're in the position of a jury, you simply say, okay, the openings aren't evidence, closings aren't evidence. The jury would have heard two different mischaracterizations of Rich's testimony. 12 jurors deliberate, and I would submit that it's very easy to conclude that they could have correctly recalled what he had to say from the witness stand. And given the testimony from Cooper, corroborated in large part by the testimony of Nelson, Rich's testimony was certainly not the sledgehammer blow to the defense that counsel would now have it appear. Rich's testimony was really not all that important in the grand scheme of things.
Well, you say that, but I mean, if the jury had a reasonable doubt as to whether the defendant was in possession of the gun, because you didn't pursue a joint venture theory here, would the jury not have acquitted?
I'm sorry, Your Honor, if the jury had a reasonable doubt.
I gather for reasons that I don't entirely understand, this was not a felony murder case.
It was.
This was purely premeditation.
No, Your Honor, it was a felony murder case.
It was a felony murder
Yes.
case.
That's actually what they convicted of, wasn't it?
No, they convicted of deliberate premeditation. The difference between the second trial and the first trial is I switched the underlying felony to attempted armed robbery based on Mr. Maidman's argument in the Burton case.
I'm sorry, I missed that because I saw that you had no longer pressed it on the home invasion, but it was still a felony murder conviction.
That's right. On a joint venture theory.
On a joint venture theory.
Right.
But the jury convicted only of
Deliberate premeditation.
Right. At least that's the only box that they checked.
Well, that's what they convicted them of.
That's what they convicted him of. You're right.
And it was tried on joint venture and principal, or just joint venture? Because this court said you could try. There was enough evidence on both, right?
Right. It was tried. Well, I guess I would say it was tried on both theories. I argued certainly that Taylor was the principal, that he was the gunman. Unless the court has any other questions about that issue, I'd like to turn to the issue of
The cooperation agreement?
The cooperation agreement and the foreclosure of cross-examination. It was the defense counsel's burden to make some type of connection between the area he intended to get into and the...
I think he did that, right?
Well, I don't think he did, Your Honor. I guess to back up a little bit, defense counsel pitched a theory in his opening statement that the two key witnesses, Nelson and Cooper, conspired to frame the defendant because he was a rival drug dealer of Burton. Now, there was absolutely no evidence to support that theory during the course of the trial. He kind of shifted gears later on to simply suggesting that Cooper and Nelson had, quote-unquote, thrown the defendant under the bus. Now, in cross-examining Cooper, he obviously he asked him, well, how come you didn't testify at Burton's trial? And that was when I objected. We went up to sidebar. I suggested that that was simply not part of the cooperation agreement and that it was irrelevant in any event, absent a showing by defense counsel. Now, then and there, he could have
Absent
made
a showing of what?
of relevance.
Well, why wouldn't it be relevant to just this theory that he was trying to he wouldn't testify against Burton, but he would testify against Taylor?
Well, there was no evidence to support that theory of bias, the rival drug dealer theory. And as we kind of hashed out at the sidebar, it wasn't part of the agreement. He had an obvious Fifth Amendment privilege not to testify at a trial at which he had no agreement in place. And it was defense counsel burden to make some type of connection, either through an offer of proof or through a voir dire of Cooper while he was there on the stand. I cited the Bowie case in my brief. I also cited the Quagan case, an appeals court case that I had a number of years ago. It's simply a burden on the defense counsel to establish some type of nexus. And he simply didn't do that. And I didn't feel compelled at that point to go into the whole history of the cooperation agreements that, in any event, is outside of the record. It would have gone into this whole other area of when they were offered, to whom they were offered, and it would have opened up a trial, potentially a trial within a trial on that issue alone.
I mean, wasn't that what he was trying? I mean, wasn't it implicit in the question that he was going to explore what? Well, you didn't testify there, and why not? And maybe the witness would say, I didn't have any agreement, and then there'd be a question about, well, why didn't you? I mean, it seems to me it does have some relevance to the theory.
Well, not without a.
Burton was there, right?
I'm sorry?
Burton was there, right? He was in the house. He
Right.
came with Cooper.
Right.
I mean, so it wasn't as if there's some unrelated trial. This is the event.
Right. But
And you don't think that a cross-examination saying you're testifying against somebody who's alleged to have been here, but you're not testifying against the other one, is irrelevant? I mean,
Yes. He had a privilege, Your Honor, not to testify.
but there was nobody said that he had. There was no. The defense counsel wasn't permitted to explore whether or not he would have asserted his privilege. Next question: why didn't you? I had a Fifth Amendment privilege and I didn't want to.
Well, I don't think that's proper material to be before the jury, that he had a Fifth Amendment privilege.
They knew he had a cooperation agreement in this case, right?
Right.
And certainly the facts, at least, were presented that he was there. I mean, he was a participant in this, correct?
Yes.
So it's not as though, I mean, I don't know that it's like somebody just coming in off the street and, you don't want the jury to know that this person has a Fifth Amendment privilege. I mean, it's so implicated in this case.
But, Your Honor, the timing of everything and the way this whole thing evolved.
You know that. The jury doesn't know that. Of course you know that. You know about the timing of the trials, the negotiations of the plea agreements. You know that.
Right, but the agreement was offered to both Cooper and Burton. Cooper accepted, and Burton, after much deliberation, declined. And because of all that, because of the length of time it took Burton to finally decide, I didn't want to then go back and alter the agreement with Cooper that he then had to
This is your explanation. You know all of this in your head. The jury knows nothing about this. Right?
That's true. But how to have them exposed to all that, in my opinion, and I would suggest to the court, That involves
But could
a
the
whole
answer,
separate
could
issue.
the answer have been, I wasn't called as a witness? Did you call him as a witness?
No,
Did defense counsel call him as a witness?
no.
So why can't you say, why didn't you testify? I wasn't called as a witness. I wasn't called by the Commonwealth. I wasn't called by the
Well,
defense.
I guess I don't know what he might have said, Your Honor, and that
No,
was
but
my
then-
concern.
Then you, somebody can object.
Well, that's true, but again, the burden is on defense counsel here. He's got to make some type of offer of proof as to where he's going to go with this, other than, all he did was simply ask the question, did you testify at Burton's trial? And he then had the opportunity at sidebar to explain where he was
And what he
going.
said was, the answer is this would indicate certainly bias towards this defendant, Taylor, as opposed to Burton. In other words, selective.
How? I guess I would ask rhetorically.
Well, because he would be presenting it. I mean, there's an answer, but he would be presenting it as that Cooper is
That Taylor was the
testifying
shooter, not
against
Burton.
Taylor, and he's not testifying, and he's not testifying against Burton. So it's selective.
But that's, it's misleading. It's not his choice.
Well, but that's what you would explore. I mean, I don't know.
Then the first question is, were you called as a witness?
Well, yeah, and then he would say no, and why weren't you called as a
He
witness?
doesn't know why he wasn't called. I don't know.
Well, again, Your Honor, I don't know what might have evolved from that point on. But I was trying to cut this off at the pass because I saw this as an extraneous issue.
But why isn't it like the Bowden type situation? The fact that he didn't testify may be relevant to a theory of the defense that he doesn't know anything at all about anything that occurred in the other trial. Or that the police didn't call him, or the police didn't do certain kinds of things in the course of their investigation. Why doesn't it reflect on the nature of the investigation?
Well, I don't think it reflects on the nature of the investigation at all. I mean,
He has nothing to offer in the Burton case.
Well, he would have something to offer.
Same thing he has to offer in this case, right?
Basically.
Burton convicted?
Yes. But, again, it's just not, it's not the same because it brings up all these other issues involving, the nature of the agreement, who was offered the agreement, Burton turning it down, all that information that has really no relevance here.
If Cooper had said to you during the course of negotiations, I'll testify against Taylor but not against Burton, would you have viewed that to be exculpatory information which would have had to be furnished to a counsel in this case?
I don't know. If it was left at that, I suppose to follow, I naturally would have asked, why don't you want to testify against Burton?
Okay, well, let me ask you, did Cooper say that I'll testify against Taylor but not against Burton?
No.
He was never asked because of what you described, this chronology.
Right.
And I'm still perplexed why, in agreement with Cooper, when Burton is still a defendant and has not yet pled guilty, would not include his agreement to testify with regard to all defendants and exclude so key a player. It's it seems a very unusual thing for a DA to do.
Well, Your Honor, again, it was offered to both of them at the same time. Burton, I thought, would eventually agree to testify as well. He never did. At that point, the case had dragged on for so long, I didn't want to go to Cooper and then say, okay, well, I'm going to change the terms of the agreement because Burton has now declined. You need to also testify against him. And the other thing is, unlike Taylor, well, let me put it this way. Taylor's the only one who did not give a statement in this case admitting he was at least present at the scene of the crime. Both Cooper and Burton did. Burton, we also found DNA on a hat that was found right outside the residence. The case was far more compelling against Burton in that regard. So for me to then go back and go to Cooper and say, hey, look, I know you signed this agreement, but I'm not going to change the terms because your cousin Burton declined, and I'm going to force you to testify against him too.
Let me just go back to this. If I have the right episode, the defense counsel asked a question, did you testify in the trial of your cousin Burton? There was an objection. The court sustained the objection. Then there was a discussion at sidebar. Defense counsel proffered this reason. His answer to that question would indicate certainly bias towards this defendant as opposed to Burton. In other words, selective.
Right.
And I guess what you're saying is it doesn't show bias because he was never called to testify.
Right.
But that was never explored.
That was never explored. Now, again, hindsight's 20/20. If I'd known I was going to be here arguing this issue, I would have put the whole thing on the record and laid out the history and this, that, and the other thing.
Was
But
Judge Giles the trial judge at the first Taylor case?
yes,
And she was the trial judge at the Burton case?
yes.
Okay, so she
Yes.
probably
So she
knew.
was very familiar
So
with
she
the...
probably had it in her head.
No, at
She
least
probably
it
had
sounds
it in
from
her
what she
head.
says,
You
though,
had
she
it in
did-
her head, your head. Unfortunately, that doesn't make the job of appellate judges very easy.
I understand, Your Honor, and, you know,
That's why
having...
we say, we have stenographers saying all the time, don't nod, say yes.
That's right, and, you know, I reap what I sow up here doing my own appellate work, and I, you know...
Some of your brothers, by the way, have learned not to bother about that. They just send some nice appellate lawyer up here.
I know.
You're very
Get the
courageous coming up
Face
here.
the music.
Does the record show that Cooper, in fact, was not called to testify in the Burton trial?
No, the record doesn't show it. I don't think.
There's nowhere, it doesn't appear anywhere.
It's just Mr. Bradley
No,
telling us
it's-
that.
Mr. Bradley knows that. The judge knows that. I don't know
I'm
whether
not-
counsel knew it, but
I think it's... No, I don't think it explicitly shows it. I think it's certainly inferable from the record that
But it's not fleshed out here.
It's not. No, it's not.
Okay.
It's not.
was
And
the reference to the First Amendment a slip of the tongue?
I don't know, Your Honor.
I mean, you weren't making that argument.
No, I
Okay,
wasn't.
okay.
It may well have been a slip of the tongue. I
And
don't
when
quite...
did Cooper plead guilty to the manslaughter?
It
Before or after the Burton trial?
was second-degree murder, actually, Your Honor. Oh, I'm sorry, Cooper. Cooper was after the trial.
Was after the Burton trial?
After the Taylor trial.
After Taylor trial.
Right.
So he had not pled guilty yet.
He had not yet pled guilty, no. Under the terms of the agreement, obviously, if he had pled, I would have lost any ability to control him at that point.
Let me ask you one other question along those same lines as to what's in the record. Is there anything in the record that Burton's case had already gone to trial?
I don't believe so.
Well, it's implicit in the record because of what the judge says.
Right. Again, it's not
Because
explicit, but it's...
The judge talks about it in the past tense.
Okay, I see. Okay.
Thank you, Mr. Bradley.
Thank you, Your Honor.
Can we take a short break?